Guardianship and Wards Act is an act which is secular in nature. That means it applies to all the religions of the our country. Now, when we speak about the Guardianship and Wards Act, the word guardian is itself the guardian of the child, and ward means the child. Now, who is below 18 years, that is minor, will be governed by the Guardianship Wards Act. Now, for Hindus, there is a special act, but for the Christians, Muslims, Jews, and also the Parsis, there are no adoption laws differently for them. Now, for this, these people can, they will also not have the absolute adoption rights like the Hindus have. But here, because there is the inheritance thing which will come in the way, which is subject matter of very long discussion, we'll discuss on some other video. But here, when I say that they do not have the complete adoption, absolute adoption rights like the Hindu child and Hindu father or Hindu mother will have, they will not have like that. There is the inheritance is also in different way. So that is the reason they will they will always go for adoption in a different way to appoint as a guardian under the Hindu Guardian Adoption Act. Now, Guardian Wards Act. Now, when we talk about the Guardian Wards Act, the feature of this act is that not only parents but the other people, maybe mama, kaka, or anybody, uncles, other people, even some other people, even the foreigners can request, can pray to the court to appoint them as a guardian. This is the best feature with the Guardianship Wards Act that we should know. Now, when we speak about the Guardianship Wards Act, I will explain you with one example. I had a first family court case with me when I started my practice, where the mother has expired, father has expired due to some accident. Now, this lady's deceased lady, the mother's brother came to me to appoint him as a guardian. Now, I was not aware whom I will appoint as a on the other side respondent, because the mother was no more, the father was no more. There was no question of they, when parents wonder who will give the adoption, the child did not have anybody, but there was a pension coming to his account, to parents account. Now the account cannot be operated because child was just 9 years old. There was a complete education which has to be completed. Now in such situation, I had under section 9 of Guardian Wards Act applied on behalf of the uncle, that is Mama, to the court at Family Court Mumbai. And I have made pro forma respondent, his uncles, and the also aunties from his father's side. They gave no objection to the Mama, and that is how the Mama was appointed as the guardian of that uh, son, that is nephew. Now here what happens, that whenever such situation arises, that there is nobody to the child, and anybody who wants to take the become a guardian of that child, he or she goes under this act. Now there are instances where unwed mothers also goes for child adoption. There are instances where transgenders also there, but now there are some reasons, and the court will check whether they are eligible or not. Now, when we speak about guardian board side, it also takes the care of the that child's welfare, his or her property. In my case, it was the not only the property, but also there were pensions coming to the account. There were also the money lying in the fixed deposit and everything. So when we speak about Guardian Wards Act, it is also about the property of the minor, and being a minor, who will take care of the same? It is the legal guardian appointed by the court will be taking the care of that minor child and his or her property. And Guardian Wards Act, one more important thing is that whenever you apply under this act, it is, I would say, easiest act to get the custody also. Because when you see the Guardian Wards Act, normally for the custody, if the child is taken to somewhere other place, we have to apply to the that particular where the child is taking, child is residing, child is going to school. But under Guardian Wards Act, it is actually like that where the child was ordinarily residing, the child is forcefully taken somewhere else. So whenever you file a custody case, you can use this section to under the Guardianship Wards Act, that where the child ordinarily resides. The word is ordinarily resides. Normally, when you go to the family court registry, they will tell you where the child is residing. File the custody case there, not here, because sometimes the mother take away the custody somewhere else. But you can always use this phrase: child was ordinarily residing and he or she was forcefully taken to the other place. So the your petition will be entered. Then Guardianship Wards Act, the most important part is this, it is not any religion. Any religion for the litigation for Parsis in Bombay High Court, we have to approach the Bombay High Court if any matter related matrimonial dispute. But for this matter, Guardianship Wards Act, we can approach the family concerned family court. For Muslims also, for Jews also, and for Christians also. So it is one of the act very secular in nature. It is a very deep act, but if you study it, it will help you. Recently, one of our participant, Nikita Sharma from Rajasthan, she was asking me about this, that there is a girl who is above 18 years, but she is physically and mentally little bit challenged. Now, in such kind of cases, when the government of Rajasthan was giving her some amount to help her, and Aadhaar card is taken out, but nobody was ready to open her account because she was neither a minor, and even though she is a major 22 years old, what happens in such cases? She cannot sign. She doesn't know anything. She was just eating food and sleeping, and just she was unable to connect with anybody. In such cases, there is a disability act also. She only enlightened me that with that act and also Guardianship Wards Act together, she can go to the court and ask for the legal guardianship, her mother being, because she was not minor here, understand, though she was physically and mentally a little bit challenged. So such kind of cases comes, then this kind of act helps you. And yesterday I was talking about that whenever you file any case, the best part before filing case, on that particular section, just find out the commentary law book, which will help you to know the past cases also and what will apply to your cases also. So this was about the Guardianship Wards Act. Very little to know about it, but it's a one of the good act which I wanted to explore today. Now next we will go to the reading by Kashi. Kashi, just a minute. I'll share the. Kashi is going to read Supreme Court
Yes, ma'am.
decision. Just a minute. This is Savitri Pandey versus Premchandra Pandey. It is by the bench of the RP Sethi and YK Sabharwal. Very beautifully written. You can start from here, Kashi.
Alleging cruelty and desertion against the husband, the appellant wife approached the matrimonial court under Section 13 of Hindu Marriage Act, hereafter referred to as Act, praying for dissolution of marriage with the respondent by decree of divorce. She also prayed for desertion to respondent to return the ornament given to him at the time of marriage. The family judge allowed the petition and dissolved the marriage of parties on the ground of desertion of by husband. The appellant was also granted a decree of rupees 12,000 towards the price of scooter and allegedly given that at time of marriage spent rupees 500 per month as a permanent alimony. Both the husband and the wife preferred appeals against the order of the family court not as the wife was not satisfied with the part of the order refusing to grant a decree in favors in respect of properties claimed by her and her husband was aggrieved by the order of dissolution of marriage by decree of divorce. Both the appeals were disposed of by impudent order holding that appellant wife herself was defaulting party and neither the allegation of cruelty nor of desertion were proved. The order passed under Section 27 of Hindu Marriage Act and for permanent alimony was not set aside. The grievance of appellant wife is that High Court was not justified in setting aside the findings of fact arrived or by a family court and she had proved that existence of cruelty and desertion against the respondent. It is contended that as the appellant wife was proved to have been living separately, it was to be presumed that respondent had deserted her. The facts of the case given rise to filing of present appeals are that Marriage between the party was solemnized on 6th May 1987. The appellant wife lived with the respondent husband till 21st June 1987, and according to her, the marriage between the parties were never consummated. After 21st June 1987, the parties started living separately. The appellant alleged that her parents spent more than 80,000 with the respective ceremonies of marriage and also give us several articles in form of ornament, valuable cash and kind as per demand of respondent. The respondent and his family members allegedly made further demands of color TV, refrigerator and some other ornament beside hard cash of rupees 10,000. The father of the appellant obliged that respondent by giving him rupees 10,000 in the first week of June 1987, but could not fulfill the demand of his parents. The respondent and his family members were alleged to have started torturing. मैम आप थोड़ा नीचे कर सकते हो torturing. Thank you. The The father of Uplin obliged the respondent by giving him a 10,000 in the first week of June 1987, but could not fulfill the other demands of his parents. The respondent and his family members were alleged to have started torturing the appellant on false pretenses. Agreed by the attitude of the respondent and his family members, the applicant has started to states to have filed a petition under Section 13 of Act seeking dissolution of marriage by a decree of divorce along with prayer for the return of property and grant a permanent alimony. The respondent also filed a petition seeking divorce and grant of other reliefs. However, on 14 May 1996, the respondent filed an application for withdrawal of his matrimonial case, which was allowed on 19 May 1996. The appellant had alleged that respondent was having illicit relations with a lady residing in Gaya at Bihar with whom he was stated to have a solemnized marriage. The allegation made in a petition were denied by respondent, and it was stated that in fact the appellant wife was taking advantages of her own wrongs. On the basis of pleadings of the parties, the following issues were framed. First, whether the defendant has treated the petitioner with cruelty, if so, its effect. Second, whether the petitioner is entitled to relief under Section 27 of Hindu Marriage Act, if so, its effect. Whether the defendant is entitled to any relief, if so, its effect. To what relief parties are entitled? Ma'am, thank you. It may be noticed that no issue with regard to alleged desertion was insisted to be framed. With respect to the issue of cruelty, the family court concluded that no evidence had been led to prove the allegation. The court, however, held, but it is proved that the respondent had deserted the petitioner. Hence, the petitioner will get or is entitled for decree of divorce. On appreciation of evidence led in the case, the division bench of High Court held we also do not find any evidence that the wife has been treated with a cruelty by her husband. We are also of view that there is no evidence of the petitioner is deserted. We have heard that learned counsel of the parties and presumed that record treating the petitioner with cruelty is a ground for divorce under Section 13, Clause 1, Subclause I of the Act. Cruelty has not been defined under the Act, and but in relation to matrimonial matters. It is contemplated as conduct of such type which endangered the living of the petitioner with the respondent. Cruelty consists of the act with the danger of life, limb, or health. Cruelty for the purpose of act means where one spouse has to treat it to other manifestate such feelings towards her or him as to have an inflict bodily injury or to have a cause reasonable apprehension of bodily injury, suffering, or to have a injured health. Cruelty may be physical or mental. Mental cruelty is the conduct of other spouse which cause mental suffering or fear of matrimonial life of other. Cruelty therefore postulated treatment of the petitioner with the such cruelty as to cause reasonable apprehension in her mind that it would be harmful for petitioner, injurious for petitioner to live with the other party. Cruelty, however, has to be distinguished from the ordinary wear and tear of family life. It cannot be decided on the basis of sensitivity of petitioner and has to adjust it on the basis of course of conduct which would in general dangerous for a spouse to live with her other. In this instant case, both the trial court as well as high court have found on fact that wife had failed to prove the allegation of the cruelty attributed to respondent. Concurrent in finding concurring finding of fact arrived by the courts cannot be disturbed by the court in exercise of power under under Article 136 of Constitution of India. Otherwise, also amendment made in a petition and evidences laid in the support thereof clearly shows that the allegation, even if held have been proved, would only show the insensitivity of appellant with respect to conduct of respondent, which cannot be termed more than ordinary wear and tear of family life. No decree of divorce could be granted on the ground of desertion in the absence of pleading of proof. Learned counsel for the appellant submitted that even in absence of specific issue, the parties had led evidences and there was sufficient material for the family court to return a verdict, desertion having been proved. In the light of submission made by the learned counsel, we have opted to examine this aspect of matter despite of the fact there was no specific issue form inserted by frame. Desertion for the purpose of seeking divorce under the Act means intentional permanent forsaking and abandonment of one spouse by other without that consent and without reasonable cause. In other words, it is a total repudiation of the obligation of marriage. Desertion is not withdrawal from the place from a state of thing. Desertion therefore means withdrawn from matrimonial obligation. It means not permitting or allowing and facilitating the cohabitation between the parties. The proof of desertion has to be considered by taking into consideration the concept of marriage, which in law legalize the sexual relationship between man and woman in the society for the perpetuation of race, permitting lawful indulgence in patient to prevent licentiousness and for precaution for children. Desertion is not a single act complete in itself. It is a continuous course of conduct to be determined under the fact and circumstances for each case. After referring to host authorities of the view various authors, this court is Bipachandra Jaisingani by Shah versus Pavitra by AIR 1957 SC 176 held that if a spouse abandons the other in a state of temporary patience, for example, anger or disgust without attending permanently to cease cohabitation, it will no amount of desertion. It further held for the office of desertion so far as desertion spouse is concerned, two essential conditions must be there, namely the victim of separation and the intention to bring cohabitation permanently to endowment descendancy. Similarly, two elements are essential for as a deserted spouse is concerned: the absence of constant and absence of conduct giving reasonable cause to spouse living matrimonial home to form the necessary intention of said. The petitioner for divorce bears the burden of providing to those elements in two spouses respectively. Here a difference between the English law and the law as enacted by Bombay legislature may be pointed out. Whereas under the English law, those essential conditions must be continued throughout the course of 3 years immediately preceding the institution of suit for divorce under the Act. The period is 4 years without specifying it that it should immediately precede the commencement according to proceeding for divorce. Whether the omission of last clause has practical result need not detain us it as it does not call for decision at present case. Desertion is a matter of interfere to be drawn from a fact and circumstances for each case. The interfere may be drawn from certain facts which may not in another case be capable of leading to the same interfere. That is to say, the fact have to be viewed as to purpose which is revealed by those act by conduct and expression of intention, both interior and subsequent to actual acts of separation. If the act there has been a separation, the essential question always is whether the act could be attributed to animus descendi. The offense of desertion commences when the effect of separation and the anomalous descendi coexist, but it is not necessary that they should commence at the same time. The fact de facto separation may have commenced without the necessary anomalous, or it may be that is a separation of anomalous descendi coincide in point of view. For example, when a separating spouse and the essential question always in whether the act could be attributed to anomalous descendancy. The offense of desertion commences when the fact of separation and anomalous descendancy coexist, but it is not necessary that they should be commenced at the same time. The defect of separation may be commenced without the necessary anomalous, or it may be that the separation and anomalous descendancy coincide in a point of view. For example, when a separating spouse abandons the marital home with the intention expressed or implied of bringing cohabitation permanently to close the law in English England has prescribed a uh, England has 3 years period, and the Bombay Act describe a period of 4 years, a continuous period during which the two elements must subsist. Hence, if deserting spouse take advantages of locus spontanei, thus provided by law, and decided to come back to the deserted spouse by bona fide offer of resuming the matrimonial home, or with all implication of marital life before the statutory period is out, or even after the lapse of that period, unless proceeding for divorce had been commenced, desertion come to end in if the deserted spouse unnecessarily refuses to offer. The latter may be desertion and not to former. Hence, it is necessary that during all the period that there has been desertion, the deserted spouse must affirm the marriage, and he be ready and willing to resume married life on such condition as may be reasonable. It is also well settled that is a proceeding for divorce of the plaintiff must prove the offense of desertion, like and other matrimonial offense beyond all reasonable doubt. Hence, though cohabitation is not required as an absolute rule of law, the courts insist upon cohabitive evidence unless it is absence of accounted the satisfaction of court. Following the decision in the Bipanchandra's case, this court again returned the legal position in Lakshman Uttamchand Kurplani versus Meena alias Moda, by holding that in instance desertion means that intentional permanent forsaking and abandonment of one spouse by other without others' consent and without reasonable cause. For offense of desertion, so far as desertion spouse's consent, two essential conditions must be there. First, factum of separation. Second, intention of recohabitation permanent to end. Inimus desert. Similarly, two elements are essential. So far as deserted spouse's consent, the absence of consent and the absence of conduct giving reasonable cause to spouse leaving matrimonial hold to form necessary intention of the set. For holding desertion, prove that interfere may be drawn certain facts which may not in another case by capable of leading to same interfere. That is, say that facts have to be viewed as to purpose which is revealed by those act by conduct of expression of intention, both interior and subsequent to the actual act of separation. To prove desertion in a matrimonial matter, it is not always necessary that the one spouse should be left the company of other, as a desertion could be proved by living under the same roof. Desertion cannot be equated or separated living by parties to the marriage. Desertion may also be constructive, which he could be inferred from the attending circumstances. It has always to be kept in mind that the caution of desertion is a matter of interference to be withdrawn from the facts of circumstances of each case. There is another aspect of the matter which disentitle the appellant from seeking a relief of divorce on the ground of desertion. In case desertion in a matrimonial case means the withdrawal from one party from state of thing. It means a marital status uh, of party. No party to the marriage can be permitted to allege desertion unless he or she admits that after the formal ceremonies of marriage, the parties had recognized and discharged the common obligation of marriage with life, which essentially requires the cohabitation between parties for the purpose of consummating the marriage. Cohabitation by the parties is an essential, a valid marriage of as an object of marriage is a further perpetuation of race by permitting lawful inclusion in a patient of proceeding of children. In other words, there can be no desertion without previous cohabitation by the parties. The basis for the theory is built upon the recognized position of law in matrimonial matters that no one can desert who does not actively or willingly bring to end the exacting state of cohabitation. However, such a rule is subject a just exception which may be found in a case ground of mental or physical incapacity of other peculiar circumstances of case. However, the party seeking divorce on the ground of desertion is required to show that he or she was not taking the advantages of his or own wrong. In
Wait, Kashi. Thank you. Very well.
Thank you, ma'am.
Just a minute. Now we move to the legal vocabulary. Today's legal vocabulary is prepared by Vandana. It's very in a short time, very beautifully prepared. Really good words. Thank you, Vandana. The first word is impugned order. Now, impugned order is the order which you are challenging before the court. Now, the impugned order of the family court is set aside as it was passed mechanically without any application of mind. See, whenever you challenge an order in High Court or other courts also, in appeal you write impugned order, just in index also. Candid.
It's
Candid,
not seen.
you can't see this?
No, it's not seen in the screen.
Wait. Let me try again. Now, the next word is candid. Candid is like a straightforward. Candid means honest actually, or somebody who speaks very clearly, straightforward, honest. The learned counsel for the appellant was candid in admitting. See, candid means honest enough to admit that the statutory requirements had not been fully met. Straight jacket formula. You normally hear these words whenever there are arguments going with two big designated seniors. There is no straight jacket formula. हाँ, कोई कठोर नियम नहीं कि ऐसे का ऐसा ही होना चाहिए. The Supreme Court observed that there is no straitjacket formula and each case requires consideration of evidence. ठीक है. Next is adjudge. The word judge, you know everybody. So adjudge. Here, to make a formal judgment, decision on disputed matter. Firstly, it prevents award of interest. Firstly, it is a sentence is formed. It prevents award of interest on the amount of interest. So adjudge on the date of the suit. Next, it fairly submitted. Normally, the Sarkari Vakil public prosecutor also says, I fairly submit, sir. That means he is very honest. Honest in the sense, he is not taking one side of the side, he is telling the truth before the court. ईमानदारी से प्रस्तुत किया गया. Phrase they use when a point of fact or law is presented honestly. Even if there is a judgment which helps the accused, the public prosecutor is saying that yes, there is a judgment. Learned counsel for the appellants fairly submitted that there is no order for running both the jail sentences concurrently. Next is vested interest. Very commonly used. A personal stake or legal right to a property of states, often implying a motive of personal gain. ऐसे बोलते हैं मेरा कोई vested interest नहीं इसमें. It was held that the will gave to the sons of the sister vested interest in their respective shares at the testator's death, though it postponed their possession and enjoyment until the deaths of the mother and the widow. Next is arbitrary manner. In arbitrary manner, मनमाने ढंग से. Petitioner has highlighted the manner in which a person has been granted parole in an arbitrary manner. मतलब without any following any rules and regulation of the jail, parole has been granted. Erroneous. Error से बना ये word. Based on an error, incorrect. See, correct, incorrect. In fact, or in the application of गलत. The Supreme Court held that the High Court's erroneous grant of bail failed to apply the necessary legal standards. While giving the bail, the High Court has not followed the legal standards. Prejudicial, harmful or detrimental to a person's right. Now, Shri Harjinder Singh, now the learned counsel for the appellants. Remember this word, Harjinder Singh, बहुत बड़े वकील थे सुप्रीम कोर्ट में, designated senior, has urged that since the appellants were in custody on so and so date, the date of passing of the impugned order of detention, there was no apprehension that the appellants would be engaging any prejudicial activity and the order of detention of the appellant under section so and so could not be validly passed. Unwarranted, anuchit, is unwarranted. जरूरत ही नहीं थी, not justified, authorized or necessary, lacking a valid legal basis. Similarly, information of prospective candidates who are considered for judicial appointments and or elevation relates to their personal information and disclosure of which would cause unwarranted invasion of an individual's privacy and serves no larger public interest. Thank you, Vandana. Very beautifully made. Now, next is the anecdote on the Pandit Kanhaiya Misra ji. Those who are from Uttar Pradesh, I think they don't need any introduction of him, and the whole of India knows him. But I thought I will share whatever little knowledge I have about him, because I have heard about him so much. I wish we could have met him or we could have heard him in this era. But unfortunately, there are no much information available about him except on the uh, internet little bit, and also a book written by his son. That is the only source of information for us. But still, I was just trying to find out something. Kanhaiya Mishra ji was an advocate general of Uttar Pradesh for the period of 17 years. This record is not broken, to my knowledge. Advocate General for 17 years. Government came and government आती जाती रही, अलग अलग government, but they did not change him. Such was his power of knowledge as a lawyer, the way he was advised. Uh, President V.V. Giri, when he was governor of Uttar Pradesh, he said, I consulted him 3 times. 2 times I followed his advice, and 1 time did not follow. And what happened? I was wrong. VV Giri sir was telling, I was wrong. I should have followed him. ये impact था उनका. And one thing he is known for, his English was such good, that when he appeared for Indian Civil Services exam that time, and he cleared that exam in English language 150 out of 150. Still, he was not appointed on Indian Civil Service exam. The, जो उनका appointment था, he wasn't. The reason was, uh, as a student, he has spoken against the British government, and he was certainly with the freedom fight. It was. So he was not appointed. Even British Parliament, they said, when he is such a ranker, why you are not appointing? This question was raised. To understand the level of his English and the level of his knowledge and his expertise. Now, when we go ahead, when he got 150 out of 150, the examiner who checked his answer sheet, he wrote for him that it is the Englishman who conquered India, but it is an Indian man, that is Kanhaiya Mishra ji, who conquered the English language. I'll repeat in Hindi that अंग्रेजों ने भारत पर अधिकार जमाया, पर अंग्रेजी भाषा पर एक भारतीय ने अधिकार जमाया. दिस वे इट वाज, मतलब ऐसे बोला जाता था उनके बारे में. He was such a brilliant lawyer with photogenic memory. Photogenic memory means somebody who remembers page number also. स्वामी विवेकानंद के बारे में भी ये कहा जाता है कि he also had a photogenic memory. Now about when इनके बारे में बोला, इनके बेटे ने एक बार लिखा है कि I asked him कि I want to know this. He said, bring that book. On this page, you will find this. Such a photogenic memory. His persuasive power भी बहुत अच्छा था. He was mesmerizing in the courtroom. ऐसे कहा जाता है when he came to Bombay High Court, इतनी भीड़ उमड़ी थी उनको सुनने के लिए. And the opponent lawyer was also mesmerized by him. The way he was beautifully arguing. That is something we should all learn from him. Even if we learn 0.001% about from his whatever material available, 150 out of 150 nahi, but 150 at his level, out of 150, even we reach to 15%, where we will be. And he was given judgeship twice, I think in 1951 and 1955. 1951 for the Allahabad High Court, and thereafter 1955 at the Supreme Court. Both time he refused, and he was the first time that because of his distinguished way as a lawyer, his knowledge of law, he was given the judgeship. First time he was given. Supreme Court say very rarely that time it happened. 1955 I'm talking about. Now to there are judges appointed directly to the Supreme Court. Then there are to small incidents of the cases. See how those who have attended my lecture regularly, they know what is I'm talking about court craft. कोर्ट क्राफ्ट जैसी भी एक चीज होती है जो आपको पता होनी चाहिए. How to behave before the court, before the in the court premises. Now there are two incidents where because he was a very senior lawyer, he was engaged by another lawyer in one tax matter. टैक्स मैटर में क्लाइंट का नाम था नेकी लाल. नेकी मीन्स अच्छा. दोज हु आर फ्रॉम द साउथ, नेकी मीन्स गुड. Now when we so he the lawyer engaged him as his counsel. When he went to the court, he started, my client name is Neki Lal, he's very good. Neki meaning so and so, मतलब संस्कार देखिए, मतलब he was, I do not know what actually happened, because what I have read, what I have understood, he was speaking about his name Neki Lal, about that. So the lawyer who has engaged him passed him a chit, argue on the case. Don't argue on his name, argue on the case. He said, I will, I will. Then the judge from the above, one of the judge asked him, what is the case? But see, the case total, I would say, the way the case taken turn, it totally changed. But it was his court craft that he was taking, bringing the judges on the, I would say, comfortable level. See, yesterday or day before yesterday, I was telling that you can't shout at the judge and get the orders. No, no. Such was the power of persuasive. This is the persuasive power of the lawyer. You have to persuade the judge. Judge को मनाना होता है. Case is not weak or strong, as Falina sir has said. It is, they are also human being. The judges are also. This I am quoting Falina sir. He is another legend. We'll talk on some other thing. Now, when he was saying this, वो कोर्ट में comfort level बन गया. So this is the way. So nobody can think, yeah, I will argue on the client's name, Neki Lal, and it was a tax matter. So he was actually, maybe to my understanding, small only, he was trying to prove Neki Lal गलत कर ही नहीं सकता. नेकी लाल नेकी ही करेगा, अच्छा ही करेगा. नेकी means good. One more example, another lawyer has engaged him, and he couldn't brief him much. जस्ट इमीडिएटली बताया था चलो कोर्ट जाना है, ये मैटर है. एंड ऑन द वे कोर्ट they became late or whatever it is, the judge from the dais said, Mr. Kanhaiya Misra ji, you have a duty towards court. See, the answer came immediately. Yes, there are duties, but it is indivisible. Two duties. One duty is towards court and another duty is towards the client. The judge was spellbound. Answer देखिए. See, if the judge asks you a question, you should know the answer. इसको बोलते हैं court craft. This is called court craft, and this is the way you should be ready with your case. The way court craft, you can. This is not drama, I would say, but a certain way of acting, because we are the attorney of the client. As an attorney, we are speaking on behalf of the client. It is not my case, it's client's case. You should be able to put in a most proper way. If the client could have put, he would not engage us. So we should be able to put in a most proper way. So these two incidents from his practice teaches us. There are so many cases, but these are too important. Then he was also engaged by Prime Minister, then Prime Minister Indira Gandhi, for an election matter, election petition, which was before Allahabad High Court. Ultimately, she lost it, and you know that the emergency was put to it. But he was engaged for some time. Later, he became sick, so he left the matter, and it was defended by some other lawyer. But all the legal fraternity held him so high. Such was his English, such was his expertise knowledge. He had a command over English, Hindi, and Urdu. He was also writing some poems also. So many things to learn from him. He was also associated with so many law colleges also, and he had done remarkable work for the public also. So he refused judgeship only because he wanted to work for the institution, that is the law field. And he had appeared before various high courts, various big, against all the big lawyers of that time. He has appeared in Bombay High Court, Madhya Pradesh High Court, so many high courts. So something we can learn from his life. There is a book by his son. Do try to read it. I'll share that name in the, and they also pick up the book in the group. So if we, this few lines can inspire you to become a better lawyer, why not? Somebody who is asked from the dais to that आपको जजशिप ऑफर कर रही, such a level, he was not asking anything, and for 17 years he was continually advocate general. Everybody used to consult him. And जब वीवी गिरी साहब president later on, he said I didn't listen to him, so it was wrong. So this is what he was, and a legend, a real legal luminary. So pranam to him, and प्रणाम to इलाहाबाद की भूमि को कि जो इलाहाबाद से है, कभी मतलब मिश्रा सर वहां रहे होंगे, और आप उसी कोर्ट में प्रैक्टिस करते हो, या वहां जाकर आप उनकी कहानियां सुन सकते हो. So thank you so much.